Welcome back in the room for those of you here in Minnesota, and welcome back from the kitchen for those of you who are online. We're going to move to our third session, our 2023 litigation update. I won't belabor the introductions too far, but we're very excited to have a California colleague join us. She'll introduce herself, but of course, as always is the case, if you want to know where the bad litigation trends are coming from, ta-da! So without further ado, I'll turn it over to the panel for our litigation update. Thank you.
Thank you, and I think it'd be pretty fair to say we really can't say that anymore. You know where the bad trends are coming from, because I think they're everywhere. That's the beauty of this session. So, studio audience, how many of you are HR professionals? And how many of you are lawyers? Okay, so for those at home, probably I'd say half and half, which is going to make this a lot of fun. Okay. With me today on my panel, I'm Melissa Raphan, are Heather Dillion and Colin Seaborg. This is Heather's first trip to Minnesota, so we need a round of applause. We told Heather that it's like this 12 months a year. So far, she believes us. Heather joined us as a partner in SoCal from an employment boutique and knows all things California and has significant experience advising employers and litigating every kind of California claim, which of course includes the acronym that none of us like to say, PAGA. She also handles discrimination and whistleblower claims, and she is very tenacious and practical, and you want her on your side of the table, trust me. Colin Seaborg commutes from Wisconsin to Minnesota each day. Can a Californian even imagine that you would be crossing state lines to come to work? I know. Colin litigates all form of employment cases, including restrictive covenant cases. He clerked for the Minnesota Court of Appeals, and he knows how to write so judges will listen, trust me. I've spent 3 decades litigating workplace disputes and can testify that some things change, the claims, and some things stay the same. When people get mad, they sue. I've litigated every kind of case in every form, and I cannot wait to see what each day brings in terms of new lawsuits. So where are we today, 2023? I think we are in somewhat of a catch your breath moment. And at the same time, the workplace is changing so fast that it's really hard to know what to focus on first. So I asked the well-known plaintiff's lawyer in town what he intends to focus on, and he sent me the list of the 14 new Minnesota laws. So I think that kind of says it all, right? It's a lot of uncharted territory for plaintiff's lawyers to dive into, and this is one area where they appear to be very motivated, finding new claims. Now, the workplace has certainly undergone more change in the last 3 years than it had in the prior 30. And I think from remote work issues to a new standard for evaluating religious accommodation claims, we're really bearing witness to the convergence of a number of factors which lend themselves easily to litigation. So we have new laws, we have new protected classes, we have the culture wars, we have remote workers who just get to watch their employer on TV, essentially. We have RIFs, we have an uptick in mental health issues, employees with new post-COVID lifestyles, which don't always align with their job responsibilities, laws demanding greater transparency, and employees who really can say whatever they want to say anywhere, anytime, according to Jack Sullivan, and that is being recorded. It's unprecedented. He said it 5 times in 5 minutes, and I just said it once in 3. But taken together, it really adds up to uncertainty. And I think whenever you have uncertainty, you have litigation. So fasten your seatbelts and join us to listen to what you need to start worrying about. Our goal today is to tell you what's coming.
And haunt your dreams, apparently.
And haunt your dreams, exactly. So here's what we're going to cover. And we're going to start with our favorite agency, the EEOC. So what's hot and what's not? You don't have to study the figures, I'll tell you. Religious discrimination charges are red hot, 7-fold jump from 2,100 in fiscal year 2021 to nearly 14,000 in fiscal year 2022. Retaliation is up slightly, but the other numbers really haven't changed. Clients anecdotally are reporting an uptick in whistleblower claims, sexual harassment, and leave claims. But I think the key really is, it's really the religious accommodation claims, and we're prepared to talk through those this morning. So what does the EEOC care about? Why do you care? You care if they care. I think that's sort of the easiest way to say it. The EEOC got a cash infusion and got staffed up. And with over 70,000 charges a year, it is very busy as always. And still, it's impossible to get anyone to answer the phone. Raise your hand if you've ever gotten through to anyone at the EEOC when you've called, right? It's important to know the priorities because you might want to work them into what you say in your position statement and what you focus on in the workplace. It seems like everyone is drinking out of a fire hose, and it's important if you can focus, somewhat. So what do they care about? They care about recruiting and hiring, and they obviously are thinking about artificial intelligence. You're going to hear more about it in the next panel, but really make sure that you can explain what you're doing. I think that's very good as it relates to any employment practice, but I think particularly in these new or uncharted areas. With respect to protection of vulnerable workers, for those of you who hire kids, I think it's important to know the EEOC is focused on that. And it's really important if you hire kids to remember there's a lot of brain research out there that says if their brains aren't developed, you can't treat them like you treat adults, because adults maybe don't understand what you're saying, but pretty sure that kids won't. So tailor your onboarding, your training to kid kind of, behavior. Pregnancy discrimination, accommodation claims, we're going to hear more about those. And I think it's really important to make sure that supervisors are sensitive to those issues. I think they maybe think, sit down, go home and rest is what they're inclined to say. And in this new world, that's not going to work. Pay issues are red hot. Equal Pay Act claims, consider a pay audit before the EEOC does. Much better for you to know what the problems are than for you to explain to them what the problems are not. Preserving access to the legal system, seems so obtuse, but here's really what it is. You got to make sure that you can defend your practices in terms of releases, and you want to stay on top of what you can put in and not put in, right? Do you use non-disparagement claims still in your releases? Do you use non-defamation claims? How do you sort of navigate that line between getting a release, but not running afoul of something at the same time? It is not business as usual. In terms of systemic discrimination, believe it or not, class-based employment claims have increased in volume in recent years. And by some counts, they are 25% of all class claims. And for class-based employment discrimination claims, which settled in 2022, the total of the top 10 settlements was about 600 million. So it's coming. I would say we saw a bunch of class action activity, then there was a huge dip, and I really do think it's coming back. And sort of next biggest kind of claim is the religious discrimination claim, religious accommodation claim. Since I've now said that 5 times in 5 minutes, I'm going to hand it off to Colin to tell you why you should be thinking about that.
Thank you, Melissa. So like Melissa mentioned, religious discrimination and accommodation claims are a very hot issue in the employment litigation world. There were a couple recent decisions from the Supreme Court's term that just ended in June, one of which you heard about already, but which was Graf v. DeJoy, another in 303 Creative v. Elenis. And since you heard about Graf, I won't go over the facts there again, but just as a refresher, the old employer-friendly de minimis cost or burden standard for showing an undue hardship to avoid providing religious accommodations to employees is out, and the Supreme Court has reinterpreted its previous precedent and now requires showing of substantial increased costs or substantial burden. I will point out that the court used that language a couple different ways throughout the opinion, so it's not exclusively tied to a showing that an accommodation will increase the employer's operating costs in some way. It can be other forms of burden as well, but nevertheless, the standard's higher to meet undue hardship. And so what's kind of the implications for employers in facing religious accommodation requests and religious discrimination lawsuits based on a failure to accommodate? Well, first of all, since the standard is higher to show undue hardship, it's very likely that employers are going to see increased religious accommodation requests, and it's also going to be harder to avoid providing them. So employers are being pressed from both sides a little bit with an increased volume of exemption requests and more that they'll have to provide. And one aspect that that may lead to is kind of a natural temptation for employers to look for other avenues to challenge religious accommodation claims. Historically, employers really haven't focused on the sincerity of employees, religious beliefs. And there's good reason for that. It's a pretty low threshold for employees to satisfy. It's very broad, it's not tied to kind of formal or orthodox sorts of religious practices. So it's pretty easy for employees to satisfy. We would caution against taking that approach still, just because of how low the standard is for employees to satisfy it. And also from perspective of the employer's operations internally with respect to their employee relations, and also externally for kind of public perception reasons. But as to the undue hardship analysis for religious accommodation requests, Groff was pretty vanilla, run of the mill. It was an employee seeking an exemption from working on Sunday shifts. But the interesting thing that we're going to be seeing is, how do courts apply this in other more nuanced and complex scenarios or requests for accommodations? And one in particular that comes to mind that we'll talk about here for a bit is, what do you do when an employee is requesting accommodation from complying with an employer's anti-discrimination policies? There's a tension between accommodating an employee's religious beliefs on one hand, and the potential for liability or just even harm to workplace culture if other employees are negatively impacted by another employee being granted an accommodation. And since Groff is so recent, there's really very little case law addressing this. There's some that kind of wrestles with it before Groff came up. But I did find one Seventh Circuit decision actually that didn't analyze the issue since Groff, but it's on this point, and I think is interesting. So back in April, the Seventh Circuit had addressed some Title VII claims from a music teacher at a public school who had requested religious exemptions from using transgender students' preferred names and gender pronouns. Initially, the school worked with him to provide an accommodation of allowing him to refer to all students using only their last names. He was kind of presenting it as like, I'm a sports coach and I'll just call everybody Johnson or whoever. But eventually the school withdrew the accommodation, finding that it was negatively impacting transgender students and other students, harming the overall school learning environment. And then eventually the teacher was terminated. He brought Title VII claims for failing to provide him religious accommodations and retaliating against him. And initially on summary judgment, the school prevailed on undue hardship, showing that, and they were arguing both that it was an undue hardship because of the impact on the learning environment and transgender and other students, but also because of the exposure or risk of Title IX litigation brought by transgender students for discrimination. The Seventh Circuit back in April.
So the employer was saying the risk of a lawsuit creates the undue hardship.
Exactly. Yes. Yeah. There weren't any brought at that point, so there weren't any pending before any courts, but just the risk of that lawsuit was one of the arguments they raised for undue hardship. And back in April, the Seventh Circuit concluded, affirmed summary judgment and concluded there was an undue hardship based on the emotional harm, caused to transgender students, and as well as the negative impact on the learning environment. They didn't address the Title IX litigation risk as a basis for undue hardship. But then just about a week ago, the Seventh Circuit actually vacated that decision and remanded to the district court to reconsider the analysis in light of Groff. The Seventh Circuit left open the possibility of reopening discovery on the claims and all of this. So it's kind of starting a bit from maybe not square one, but it's, potential for it to have new life in that case.
I bet we see a 303 creative claim too, the First Amendment protection of speech too.
Exactly. And so what?
Isn't this fun? Like the law is just being made. It is being made every hour though. I mean, and that is not an exaggeration, don't you think?
That's why we have jobs.
Yeah. And so the 303 creative decision that Heather mentioned is another decision from the Supreme Court this last term. It's not directly an employment case. It's a First Amendment free speech claim. It was brought by an owner operator of a company that provided a wedding and graphic design service, or website and graphic design services. And she planned to provide wedding website design services, but brought a lawsuit against the state of Colorado for an injunction to prohibit enforcement of its anti-discrimination law, which would generally require public accommodations not to discriminate when they sell goods and services. And the Supreme Court in 303 did end up concluding that the website design services, which the owner operator objected to providing to same-sex couples based on her religious beliefs, the court concluded that was expressive services, and so fell within the protections of the First Amendment free speech clause. And the court, recognized that states and governments have a compelling interest in eradicating discrimination in places of public accommodation, but ultimately concluded that the statute went too far and was too broad in restricting the individual's free speech constitutional rights not to be compelled to state a message in which she didn't believe by providing custom wedding websites to same-sex couples. And so the immediate implications of 303 creative for employers aren't necessarily apparent, but there are some scenarios where this could come into play for employers as well. The first is that just the public awareness of this decision may result in more employees coming into your offices and saying they have these free speech constitutional type rights, which, unless you're a public entity, don't apply to you. However, employees may kind of under the surface be bringing up topics or instances that could be protected under Title VII that you should be aware of.
How would they know? Like, you know what I mean? Like, how would you know if someone came into your office and said, I can say whatever I want under the First Amendment? How would you know if it was a Title VII claim?
Yeah, so if it's purely free speech related, like 303 creative was, it wouldn't necessarily implicate a protected class under Title VII. But if they're bringing up something talking about their religious beliefs, and this is why they're saying something, that should raise flags about, is this something that they're talking about that might be protected by Title VII.
And I see this a lot, and I think half of this group is HR professionals, are HR professionals. I'm sure you see it too. Someone comes in, or you bring someone in for saying something rude or terrible to someone else, and they say, "Oh, I have a First Amendment right." Like that's not what it means. So just kind of explaining to them, I'm not going to tell you, hey, but tell them you might have a Title VII right, but look into it and really educate your employees. Yes, you are free. The government says you can say rude things. You can say discriminatory things, but in this workplace, and hopefully you can guide them to your employee handbook that has specific provisions that say that's not how we do things here. We expect a higher standard of you than the government does. So but I just expect to see this a lot more now again.
I had a client say, give me some, say this, and this was super helpful. So, in a circumstance where employees kind of say, well, I should be able to say this, you say, look, it's not illegal to wear a bathing suit to work, but you may not wear a bathing suit to work. I mean, that's just so simple. Everyone can understand that, right? So I think that you could use that line.
But there is some, as the case law gets developed, there is some risk out there that this 303 creative could be combined with Groff, in the sense that, and in particular, I'm thinking of states that have anti-discrimination laws that provide for individual liability for an employee for discriminating. Well, they may say, extending 303 creative, I have a constitutional right, to engage in this protected conduct or whatever it is. So the statute, Title VII, or whatever the state anti-discrimination law is unconstitutional. And if the employer takes adverse employment actions, disciplining the employee, terminating them, they could then conceivably bring retaliation claims based on an employee's exercise of political or constitutional rights. So it's complex, and there's a lot left to be kind of determined by courts, and I imagine there will be plenty of creative plaintiffs attorneys out there who are working on developing these theories. But it's something to be aware of and have on your radar. The last point on the PowerPoint that I'll get into that kind of falls into this category for religious exemptions is on vaccine cases. Over the past few years, they've largely been pretty unsuccessful with respect to religious exemption claims. After Groff, there may be new life in those as well, since it's a higher standard for employers to show undue hardship. I will point out that, again, there's very little case law applying that in vaccine exemption context since Groff, but I did find one out of the Southern District of New York from the end of June, which did actually consider Groff in the analysis, but there the employer was a medical facility, the employee was a nurse, and there was a New York state mandate requiring employees to be vaccinated unless it would impact their health. There wasn't an exemption for religious beliefs under that mandate. And the court ended up concluding that it would have been an undue burden, undue hardship, even under Groff, to expose the employer to liability under the mandate to allow that exemption. So those are possible arguments out there, but just be aware those may kind of vamp up again.
So I think if you feel squeezed, you're right, you're squeezed. I mean, it's true.
All right, well, let's dig into this a little more and squeeze you a little harder. So what's been really interesting with the Groff and 303 Creative holdings is looking at it and juxtaposing it to the Title VII rights. So just a little background, which I'm sure you all are well trained in, but certain definitions are important to just make sure you know as you foster an inclusive workplace. The gender identity is the internal sense of being male, female, non-binary, etc. Gender expression is external characteristics and behaviors perceived to be either feminine or masculine. And transgender is an individual's gender identity or expression that differs from their sex assigned at birth. Then we have Title VII that prohibits discrimination by employers against employees or applicants on the basis of race, sex, color, religion, and national origin. Bostock versus Clayton County is a 2020 U.S. Supreme Court case, and this was the first case federally that said gay and transgender rights are protected within the sex aspect of of Title VII. As we were discussing this together, I said, well, California has been way ahead of the curve. And Melissa said, hold on, so is Minnesota. So,
Same weather,
sorry.
same laws.
But in California specifically, in 2011, the FEHA codified protections and included gender identity and gender expression as protected characteristics, explicitly making it unlawful to discriminate against applicants and employees because of those characteristics. In the wake of those changes, the DFEH also issued guidance saying that employers must apply dress codes and grooming standards in a non-discriminatory manner. So it's been happening in states, and our federal government's a little slower to catch up many times, but this has been something that has been brewing and that the protections have been growing over the past decade. So what does this look like? An employer should allow a person to dress and use restrooms according to their gender identity, regardless of their sex assigned at birth. So that was a little background to bring us all back up to speed. Now we're at this intersection of religion and gender identity or expression. And this is really helpful. The current landscape is unknown. We don't know. We really don't know. The 303 Creative and Groff decisions, while we anticipated them, they still came down pretty narrowly. It was a pretty narrow, for Groff, it was, listen, you're the US Postal Service. Certainly somebody else can work on a Sunday. 303 Creative, they said, well, this may be a little, of a stretch, but a free speech, and we can't move in on her free speech. So they're very specific cases. So there's a bunch of case law prior. Obviously, those just happened. We don't have much case law. The case law that I'll get into after says, counsel, why don't you go ahead and rebrief this in light of the recent decision? So the court's punting even a little bit more. But three questions that have been raised a couple of times. First, can employees receive a religious accommodation from using other employees' preferred pronouns? Can employees criticize employers' support for pro-gender identity legislation? Can employees receive religious accommodations from attending gender identity trainings. So the Bostock case that solidified transgender and gay rights from employment discrimination left questions. This is not on your next slide. I'm just jumping all around, guys. I'm from California. We do crazy things. I just wanted to point out that even before today, in 2020, the court held, when that was the case that held that Title VII expands to transgender and gay rights, the court said, we are deeply concerned with preserving the promise of the free exercise of religion enshrined in our Constitution. That guarantee lies at the heart of our pluralistic society. But worries about how Title VII may intersect with religious liberties are nothing new. But how these doctrines protecting religious liberty interact with Title VII are questions for future cases. Thanks, guys. And that's still today. So we don't have those answers, right? It's all these courts are punting, and it's going to take a very, very fact-specific case for them to weigh them. And what I think we're going to end up seeing is whomever's on the court at that time, you'll figure out how they categorize these protections. What's category 1, what's category 2, and how they put them against each other.
Right,
So
sort of the order of operations. I mean, I think as employers, you're going to find yourselves in positions where you have to decide which lawsuit you'll take, because you're going to be sort of dead center and you're going to have to make a decision.
exactly. So there are some current cases that are pending that have been somewhat helpful. There is that case that I told you about, and that is, what is that one? One of them that I mentioned that's punting and said, hey, go back and check that out. But we have Haskins versus Bio Blood Components, and this is a Michigan District Court case. There, the plaintiff did not want to refer to her coworker by his preferred pronouns and requested a religious accommodation. The company denied her request, asked her to resign, and eventually terminated her. The employer lost on a motion to dismiss, arguing that the accommodation would expose it to Title VII liability. Importantly, this is a motion to dismiss, or as we call it in California, a demur. So it's very narrow what they're looking at. But what they looked at here, the plaintiff was able to articulate a sincerely held religious belief. She also offered up a couple different accommodations, and the company essentially just said, no, you're gone. So how that will land, we're not quite sure, but it is still interesting to see these start to really play out, and how they'll play out with those two cases.
And what do you recall what she offered?
She offered to do the last names was one thing.
Yeah.
She requested to be transferred to a different department. She offered to not interact with that employee.
Okay, she made these offers. Yeah. Okay.
But the transferring, the employer said, oh, we can't transfer you. And that was it. So that probably should have been engaged in a bit more.
Right. So it's a little bit like the interactive dialogue, right? That you have to bring, even though Colin taught me that that's not the analysis the court applies, it would serve you well to do it.
Yeah, like Rebecca mentioned earlier, the court in Groff didn't go so far to say as the process for determining undue hardship under the ADA applies here, but they didn't give really any guidance about what that actually means and how it's different. They did, and they also simultaneously didn't approve all the EEOC's existing guidance on religious accommodations, but suggested that much of it may be consistent with our holding today. So, but I would fully expect the EEOC to take the opportunity to revisit its guidance on these issues in light of the new decision in Groff.
And we're finding that we're looking at all these cases, and I won't take you through each one, but that the court really looks to whether there is a sincerely held religious belief, and then if it's an undue hardship. And there was a case that out of Idaho, believe it or not, in 2004, where the court there, or what happened there was an employer put up diversity posters encouraging or showing multiracial and gay couples. And this employee put up in his cube a bunch of Bible verses, including Leviticus, very large fonts. And when they asked him, why did you put this up? He said that they were meant to communicate condemnation of gay behavior. Okay. So the court said that that was not showing a sincere religious belief. And in fact, the court went even far to say We seriously doubt that the doctrines to which Peterson professes allegiance compel any employee to engage in either expressive or physical activity designed to hurt or harass one fellow's employees. The court also found that it would create an undue hardship because his proposal was fine. I'll take them down if you guys take your posters down. Otherwise, I get to leave it up. So the court said that's the employer said, no, it doesn't work. And the court said that would create an undue hardship because it would inhibit defendants' effort to attract and retain a qualified, diverse workforce, which the company reasonably views as vital to its commercial success. So I think that's one of it's not a money issue. It's not, it's looking at the core company values. Make sure you have those in your employee handbooks and other places that you can turn to.
And so it is an avenue, I think, after Groff, especially though, it's to make that showing in court, you're going to need to do more than just provide kind of a really high level statement of this is, workplace diversity and culture is important to us and it negatively impacts us. If there's an employee kind of harming that work environment, you're going to need to do, I think, more to meet the level of an undue hardship after Groff.
Well, and I think those points are great. And I think what employers are going to want to do is make sure it's in your handbook. And if it's really embedded in your culture, then I think you stand a much better chance of saying it would be really what we're being asked to do is abandon everything that we stand for. And, to accommodate this employee.
So my last slide on here is what can you do? Acknowledge differences in opinions and beliefs. This is hard work. It is personally and morally complex. It triggers a lot of different things for different people, but work with your employees, have strong policies, have strong, strong morale. 2, engage in respectful conflict resolution.
And just on that front, what we are seeing more clients do is bring in outside mediators to facilitate workplace issues. These sort of community-based conflict resolution centers are being called in for these issues.
Perfect. Understand what is legally protected. That's clear, right, guys? Since we know that sincere religious beliefs are potentially protected, bigotry is not. It's very rare that a religion pushes do not love thy neighbor. Be careful about claiming undue hardship. It's a very case-by-case analysis. And when it goes deep to the culture, we've seen that work, but we've seen other areas where it does not work, a lot of areas. And seek advice, turn to your trusted in-house counsel or outside counsel, whomever it may be. These are fact-specific analyses. This is not all right, here, I take this path and then go. So really dive into the facts. And I think my last chart is just showing that we are seeing an increase in these claims and the LGBTQ plus based claims. It's going to continue. I don't see this slowing down anytime soon. We also believe that you've seen the religious accommodation claims go up. So these two are probably going to just slide up together.
So, pay transparency laws really, I think, serve as a funnel for Equal Pay Act claims. And beginning about 5 years ago, we saw a huge legislative push to really shine light on what people get paid. Now, 20 years ago, employers had handbook provisions that said, if you ever disclose your compensation in the workplace, you're going to be fired on the spot, and that was fine. So we have come a long way from there. That is the truth. Now, I think the key here on these pay transparency laws is make sure you know what they are and make sure you know where your employees are so you know which state's laws apply. I think that's really been critical. And well, it's been very surprising, right? I think in this sort of post-COVID time, employers have learned that their employees are places they never imagined. Sometimes they don't even know where the places are, but they still have to comply. So not winning your school geography bee is not a good defense if you can't figure out which law to apply.
That is a California true problem. We are the worst at geography. Everything is just
No, New Yorkers are, they don't care because they don't even care.
Oh. I try.
Yeah, well, they don't. So about 24 states have enacted pay transparency laws, and there are 2 to come. New York and Hawaii. Here's a warning. This New York pay transparency law carries a 6-figure penalty for first violations. So run, don't walk, and figure that one out. You really need to pay attention because everyone is different and everyone is a little bit different. Now, it's really important to pay attention to disparities for employees holding the same job. So Equal Pay Act claims, because the EEOC is very focused on this. They've indicated that in their enforcement priorities, and 2 recent decisions bring that home in case you need to, tell people in the workplace that you can prove what you're saying makes sense. There's a recent case where the EEOC settled for about 100,000, another one where they settled for 200,000, but I will tell you, and anyone who's done this knows, litigating with the EEOC is extremely unpleasant. It's very disruptive. It involves, way more than money in your workplace, and you really don't want it to happen. So if you need a rationale for why your company should pay attention, consider this. In 2022, Google settled a pay discrimination claim with a class of women for $118 million. And that's not the bad part. Here's the bad part. For 3 years after a formal approval of the settlement, Google has to let third-party experts assess how it could improve its pay equity process, how it could be fairer when establishing rank and pay for new hires. And then there's an external monitor to determine whether Google complied with the third party's recommendations. That is just not what you want in your workplace, I am sure.
And Google's having to pay for all of those, right?
Of course. Absolutely. Pregnancy discrimination claims, you've heard about it. The beauty of being the third session is you've heard so much. By the time you've gotten to us, you know what you should be worried about. So the Pregnant Workers Fairness Act just took effect in June of 2023. And I am really convinced that plaintiffs' lawyers get alerts on new laws, and they will be adding this to their template complaint by Labor Day. And you will all know it by heart by Halloween, I am sure. Okay, sexual harassment claims, nothing really new on that front. I think I would just say remote workers, very unique ways to bring these claims. I'm really going to just have to leave it there. I'm going
We're
to
seeing
hand
that,
it
by
off.
the way.
You are?
Yeah.
Are you care to share any stories?
Well, they're just through text messages, things that are sent via text message or cute names that supervisors call people through emails, even writing people.
Well, I would say, and the person who shared this story with me is in the room. Imagine this on a Zoom call. It's not your time to speak, so you're muted. I don't know. I mean, when I'm muted, I'm usually waiting to speak or waiting for my turn. This person actually had sex, but didn't realize that she really wasn't on mute during her time where she was just supposed to be waiting to speak. Okay, I'm passing it to Colin now.
Well, I think that one part.
Oh, this is Colin's going to address.
Oh, okay. I thought this was yours. Sorry.
No,
Have fun.
follow that up. The federal government wants to keep these claims in the public eye, I guess, if you will. So there's a couple of the more significant developments with respect to sexual harassment claims are just 2 pieces of legislation that the federal government passed within the past year. So the first is the Speak Out Act that you see there. So that invalidates pre-dispute, non-disclosure, and non-disparagement clauses that relate to sexual assault or sexual harassment claims. And that applies to claims filed as of the effective date from December 7th of 2022. The predecessor to that by about 9 months was the Ending Forced Arbitration Act. And so that applies to pre-dispute arbitration agreements and pre-dispute joint action waivers relating to sexual harassment disputes and sexual assault disputes. And so that applies to disputes or claims that arise or accrues as of the effective date, which was March 3rd of 2022. So I think the key takeaway on this is that, generally be aware that pre-dispute arbitration agreements, non-disclosure clauses, non-disparagement clauses that are related to sexual harassment or sexual assault aren't valid going forward. Now, neither act is retroactive per se, but there are some traps to be aware of, particularly with respect to the Ending Forced Arbitration Act. And so as you can see with the language on the slide, it's phrased a little differently between the two acts. The Speak Out Act applies to claims filed as of the effective date. The Ending Forced Arbitration Act applies to disputes or claims that arise or accrue as of the effective date. And courts have, uniformly agreed that if the claim arose and a charge or lawsuit was filed before March 3rd of 2022, the EFAA doesn't apply and arbitration can go forward, assuming it's otherwise a binding and enforceable agreement. Where they've struggled more is when, say, the claim for sexual harassment arose before March 3rd of 2022, but the charge of the lawsuit wasn't filed until after that date. And what does the language dispute arises mean? In some courts, they've interpreted that to mean more when the charge is filed or when a lawsuit is filed. Other courts have gone the other way and really concluded that the dispute arises when the underlying conduct occurs. And so there really isn't a lot of appellate case law on this, because since it's still only about 1.5 years old on the Ending Forced Arbitration Act, but the district courts that have addressed it, there's one recently out of the Western District of Pennsylvania that I think provides good analysis on the dispute arises issue. And essentially there, a female lifeguard had alleged she had been sexually harassed and was terminated. And prior to that experience, she had signed an arbitration agreement with her employer. And she filed an EEOC charge in September of 2021, and then later brought a lawsuit in September of 22 when, after she got her right to sue letter, the employer moved to compel arbitration, and the court granted that. And the court rejected her argument that the dispute arose when she filed the lawsuit, and really went into pretty in-depth analysis of what dispute arises should mean. But I think one of the points that it made most persuasively in my mind was that if you interpret dispute to mean when the complaint is filed, well, the EFAA only applies to pre-dispute arbitration agreements. And so if you interpret that way, you could have a situation where sexual harassment occurred, the employee later agrees to enters an arbitration agreement with the employer, but before filing a charge of a lawsuit, and that would not be enforceable either, which doesn't make sense, isn't really a reasonable interpretation of the act. So I'm hopeful that courts will latch on to that viewpoint, just to clarify and what the act applies to. And you can see in the Speak Out Act, which came later, I think Congress may have realized that there was a bit of some sloppy drafting in the Ending Forced Arbitration Act, since they applied to claims that were filed as of the effective date.
Okay, but who compels a lifeguard to arbitration? I mean, seriously.
I mean, I probably would if I was defending the county.
But one other quick point on the Ending Forced Arbitration Act is that it's not immediately apparent from when you do a quick reading of the act, but be aware that it may not apply exclusively to sexual harassment claims. It applies to claims related to sexual harassment, but the invalidation provision of the act actually says it invalidates arbitration agreements as to a case relating to sexual harassment claims or disputes. And so there are courts out there that have held that not only does it apply to a sexual harassment claim, it can apply to the retaliation for reporting sexual harassment claim. It can apply even to completely unrelated claims. So out of the Southern District of New York, again, there was a decision back in February where the court concluded that the plaintiff had alleged plausible claims of sexual harassment, and therefore the arbitration agreement, which was subject to the EFAA, wasn't enforceable anymore. And that applied to her sexual harassment claims. She also had race discrimination, pay discrimination, whistleblower claims, common law, intentional infliction of emotional distress. All of those claims stayed in court despite the arbitration.
And that's what we're seeing. We're seeing I think we're going to see, I at least personally have an uptick in sexual harassment claims. And my viewpoint is they're trying to avoid arbitration. So there's that. I know we're close on time.
No, we have all the time in the world.
This is Melissa's world. We're just living in it.
Yeah, we got about 6 minutes.
Okay. quickly, I'm going to discuss disability claims and how they're relating to remote work and the COVID world. I'm going to go through this really quickly because I'm so tired of talking about COVID. And remote work. Remote work's here to stay. It's here to stay. Obviously, different companies can work differently and require a different level of being present in the workplace. The EEOC has issued some guidance. They love issuing guidance, and looked at a significant expense. Prior to COVID, we saw employers saying it is a significant expense or just a hardship for us to have employees work from home. Then we all were forced to do it, and it worked somewhat, right? But it worked in some places. So the question is now, can you truly say, where an employee gives you a doctor's note that said this employee needs to work from home, can you truly say, no, it's an undue hardship? You really have to weigh the facts. You really have to look at them. The courts differ with how they're going. But there are places, for example, one of these cases are here where it didn't work it was an FAA employee. Like, we need you in the tower. Like, I understand it works for a while, but we really need you up there. Another one who had MS requested an accommodation to work from home when the MS flared up. The employer said no. Surprised me. And then the employee quit, saying, well, they forced me to do this. The court held that they found the facts show that the employer actually let them do so when it flared up. They weren't that much of a jerk. And that their claim that they have to be there to take care of this, the lower level employees, was ridiculous. So just really look at it on a fact by fact basis. And I blew through that because I knew we wanted to chat.
Yeah, we want to talk about the social media issue.
We do want to talk about the social media issue. What
Okay,
social media issue?
so what about an employee who, not a supervisor, posts on LinkedIn about the Budweiser issue, which maybe you want to explain, and basically says, I certainly hope our company is not going to go the Budweiser route. Coworkers pick up on the post, bring it to the supervisor's attention. What does the supervisor do? I think these social media issues often, they really highlight this issue between sort of, sincerely held religious belief and kind of the free speech.
I think there are a bunch of layers there, as you might imagine. For those that don't know, the Budweiser issue was they had a spokesperson who was transgender, and a lot of people went up in arms. Not everyone. A lot of people went up in arms and said, this is horrible, and stopped drinking Bud Light. And Bud Light sales actually tanked significantly. And Modelo is now the #1 beer consumed in.
Well, that's a whole different thing, Bud Light.
I feel like it should have been that way anyways, but that's beside the point. So for them to say that, they are saying, I can't believe this company supported a transgender individual. Hopefully our company won't. But one, are you a government company? If you are, you probably need to stand down on that one. Two, do you have a social media policy? You should have a social media policy. You should have a social media policy that reinforces your company's values. And be careful. So some companies will have, okay, for LinkedIn, you're automatically connected. What I'm saying is, it's Heather Dillion, Dorsey, Whitney. So you can require employees that if you connect your company name, that you disclaimer, this is not my company's views. But what does that really do? Because here you're looking at the culture, and maybe going back to that Idaho case that said it is an undue hardship to not support this culture of inclusivity. So I think it's a very careful situation. And this was brought because this is a real situation that people are dealing with now. But again, it goes down to having your policies ironed out, have that information in there so you can point to something and make sure you're not enforcing it in a discriminatory manner.
Well, it probably, makes a difference if the individual is a supervisor or not. Right. I think that also is something to consider.
I think it's different if a post said, my religion does not believe in transgenderism. I don't know where it says that in any Bible, but I also don't know a lot of Bibles, but and that kind of, that would be a little different, but I think we all get so emotional with these. You're well charged one way or another, right? Or somewhere in between. But I think it's important, especially to HR and legal professionals, to take your emotional charge out of it and go to that employee and say, hey, why'd you do this? What's going on here? And really work through it.
Yeah, I
And
think
I-
you, yeah. go
Oh,
ahead.
good. And I think one aspect to that type of scenario, an employee making those sort of posts on social media or comments in another way, is that can play into it. You know, did they actually request an accommodation before? If they didn't, then there's not, you know, a failure to accommodate by taking some action after that. And there's also the impact of, you know, is the employer aware beforehand that an employee has these religious beliefs that is leading them to make these statements? If not, then it's not religious discrimination to terminate someone in violation for conduct in violation of, say, a social media policy or other, you know, kind of workplace anti-discrimination laws, since the employer was doing it based on that violation of the policy, not based on knowledge that the employee was doing this because of their religious beliefs. So it can depend too, like on the content of the post, you know, if, like Heather was saying, the post explains that they're saying this because of their religious beliefs versus just a post that goes kind of on a rant about something.
Yeah.
So it's fact specific, but again, is another area where red flags should be on coming up for you if you encounter things like that.
Yeah, I would say very multi-layered nuance, you know, you really want to have a strategy and figure out what you're going to do, why you're going to do it, and document it.
Document.
I think the bottom line for this session is you are going to find yourself in situations that are not risk-free. I mean, you know, you really are facing more risk than you ever have, and you have to be very comfortable picking which risk you want to take and, you know, getting ready for it. I think the bottom line is you really have to be prepared for the claims we have always seen and be prepared for what you do not know is coming.
All
Okay.
right.
Thank you.
Thank you. So we are at our final break, 10 minutes. We'll be back at 11:45. Just a reminder to everybody in the room and online, if you want CLE and HR credit, remember you have to sign in for each session. So if you're online, make sure you're sending the emails and complying with those instructions. For those of you in the room, we do have the green sheets. If you missed the green sheet for an earlier session, we have them out on the table, so stop by and sign in for those. We will see you in 10 minutes.